Everyone, welcome to our lesson on international law, which will be about individuals today. I will speak about individuals to you, and hello. This term individuals in international law, individuals. I am using this term in a large sense. I would like to include in this concept both people, physical people, and also non-governmental formations, non-governmental entities, as firms, companies, associations, NGOs, which means non-governmental organizations, etc. But there is also a strict definition. There can be also a strict definition, a narrow definition of the concept of individual. In that sense, narrow sense, individuals are only natural persons, physical people, human beings. In that lesson, I don't use the term of individuals like that. I include in the individuals, in the concept of individuals, all private law persons, so also judicial persons, also called in legal terminology as juristic persons or legal persons. Those persons, judicial persons, or legal persons, or juristic persons, it refers to fictitious personality of non-physical subject of law. Non-physical subject of law are firms, companies, associations, NGOs. So there is an important difference between domestic law, national law, in one hand, and international law in the other hand. In the national legal order, all persons, natural or legal, all persons, physical or not physical, have the legal statute of subject of law. All persons are subject of law. Human beings and companies, firms are subject of law. They are legal subjects, and as such, they have legal abilities. They can not only get rights and duties from the legal order, but they can also act in the legal order by creating rights and obligations. For example, a student can get a loan, a credit, with a bank. This student, he or she, can create by her or his action, by her or his signature, legal signature, he can or she can create duties, legal obligations, or rights, legal rights, between her or himself and the bank. Legal persons non-physical persons in internal law can also act legally by contracting with other subjects of law, by contracting with other legal persons or other natural persons. In my example, for example, in my illustration, for example, the bank is a fictitious legal person creating duties and rights between itself and the students. Because there is a loan contract, which is a legal act, which is a legal norm. To summarize a little bit, we can say that the ability of normative creation, the ability to create normative rules, legal rules, is the main characteristic of legal subjects. Only legal subjects have this ability to create norms, to create legal rules in the legal order. Legal objects, so I'm telling objects and not subjects. In contrast with legal subjects, legal objects, as such as animals, buildings, plants, tools, values, for example, money, they are not legal subjects. They don't have any normative ability. They cannot act normatively in the legal order. A cat, for example, an animal, a cat, cannot sue its owner before a court of justice. A dog cannot have a bank account. Only legal subjects can act in law. Legal objects cannot act in law. They don't have legal abilities. Even though they can have protection, even though they can have safeguards, rules about them, themselves, animals, buildings, tools, legal objects, themselves, they cannot create law, they cannot create rules. So, this was the situation in the domestic law, in national legal order. In contrast with this situation in domestic laws, in the international legal order, individuals have no normative ability because they are not legal subjects of this order. They are not legal subjects. Individuals are not legal subjects in the international legal order. So make the distinction. They are subjects in national law. They can create rules. They can adopt, conclude contracts. They can create normative rules. But in the international legal order, they cannot create rules. Their action, their acts are not creating any international rules. So, individuals cannot conclude an international treaty. They don't have enough sovereign power or competencies to be legal actors capable to create international norms. Only sovereign states and international organizations can create those kind of international rules. So, the international law is a matter of public authorities. It is not created, it is not normatively produced by private persons. Sovereign states, on the basis of their sovereign will, their free will, their sovereignty, they will sign and ratify international treaties. And, for example, they create international organizations. EU states, member states of European Union, they have created the European Union by signing in 1992, the Maastricht Treaty, which is entered in force in 1993. And only international organizations created by sovereign states which transferred to them limited competencies, only those organizations can create international secondary law norms. Secondary, why I'm telling secondary? Because the treaty is the primary law of the international organization, and legal acts of the international organization are only secondary norms derived from the treaty, adopted on the base of the treaty. So there is a hierarchical link between secondary law and primary law of international organizations. For example, states have created the United Nations by the conclusion of the United Nations Charter. The Security Council, which is one of the major institutions of the United Nations, can adopt mandatory international norms, which are resolutions, UN SCR resolution, UN CSR SCR resolutions, and which are binding for member states. So, as we see, only legal persons of public law can create norms in international public law. And so only states and international organizations are legal subjects of international law. Individuals, which are legal subjects of national private law, they cannot conclude treaties, international treaties. They cannot create international organizations. They cannot create international customs by their behavior. Their acts are not normative production of international law. But individuals are getting more and more importance progressively in international law. In our changing society, where sovereign states are more and more fragile, are more and more unable to resolve global crises and are unable to answer to new challenges, the monopoly of public persons, public authorities in international law is getting less strong, and private persons are becoming more and more important. A few examples. They are commercial actors in international legal order. They are humanitarian actors in international legal order. And they participate to global issues. They are consulted for global issues. So first example is about the fact that individuals are commercial actors. Since always, even during ancient times of humanity, there are always international trade between nations, and the international trade gave birth to the law of international trade. The international trade law, which is also called lex mercatoria, has its origin ancient international trade relations. Always about commercial activities, international activities. In 17th century, colonialism of Western states gave birth to international companies, chartered companies of England or France, for example, in Egypt, the Suez Canal, in India, the Levant Company of England. So private persons supported by public authorities are affecting international legal order and also international relations. The boundary between public and private person can be blurry, can be unclear. Example, there are big national companies like Total for France, Alstom, or BP, Shell for United Kingdom. So those companies can affect the international order, the behavior of states, behavior of sovereign states in international order. So sovereign states can hide their existence behind private persons. Also, private individuals, private particulars can affect international relations and make states create an international law. For example, Julian Assange, the alert launcher, in this case, European Union has adopted a new directive in order to protect alert launcher of violations of the European Union law. So this was the first example. They are commercial actors and states are behind those persons, and we can see individuals also link it to international relations. The second example is humanitarian actors. The international civil society can also act very influently, with the very important consequences in international legal order. For example, in 1863, the famous private law organization, the International Red Cross Committee, the International Red Cross Committee is created. The International Red Cross Committee is a private law person. It's a legal person of private law. It is not a public authority. The International Red Cross Committee is a private authority, a private law person. It's not a public authority, but it can have some competencies, some specific relations with public authorities, and it can intervene in some international humanitarian issues. It can benefit from privileges on international legal order, and there are treaties to protect. There are international agreements to protect the International Red Cross Committee. It is the same thing for the International Olympic Committee, created in 1894, which is a private person, which is a legal person, which is a judiciary person, but a private person, which is not a subject of international law, but the Olympic Committee can benefit from several privileges, attributions before public authorities, the immunities, for example, and so they can be in interaction with public authorities, with subjects of international law, in the legal order of international law. So, as we see in this example also, private persons can have interactions in international law, even though they are not subjects of international law. My last example is about globalization issues. The place of private persons in those issues. Private persons can participate to international discussions, to international normative activities indirectly. In this case, they are not creating the norm, but they are contributing to the creation of the norm. It is the example of the United Nations NGO consultations. The United Nations commissions and committees in issues of global warming, in issues of climate change, in issues of humanitarian disasters, immigration, etc. United Nations can consult those NGOs specialized on those matters, and there are approximately 4,000 NGOs acting before the United Nations. And as you can see, several conventions, several treaties, several agreements proposed by the United Nations to the signature of states are realized, are elaborated after those consultations of NGOs. You can check, for example, the Article 71 of UN Charter to see the place of NGOs before the assembly, the Parliamentary Assembly of United Nations. European Court of Human Rights, another example about those participation of NGOs, which is not an example of globalization, but which is an interesting example for Europe. European Court of Human Rights also can check NGOs' reports while it's making its judgments on the violation of fundamental rights in the case of in cases of violation of European Convention rights, fundamental rights. For example, in cases of extradition, the European Court of Human Rights, in extradition case, when a man or woman will be when a man or when an applicant before the Court of Human Rights is making an object of extradition to a country where human rights are not protected, the Court of Human Rights checks NGO reports in order to make the proof that, to make its appreciation on the violation of human rights in those countries. So let's make a 10 minutes of stop, and we will take the lesson after that.